Hi, Lee Phillips again. I want to talk to you about maybe a touchy subject, estate planning. Yes, I am an estate planning attorney. I am nationally known. I have written a best-selling book called Protecting Your Financial Future. If you will call my office, I will give it to you not at the $24.99 or whatever it is that Amazon charges, but I think we can get it to you for about $8 plus a couple of $2 shipping. So it's a great book, and it talks about the estate planning process and what you need to do. We did a lot of fancy stuff for Christy and had a fair number of assets, so we took the tax considerations very seriously. You're probably not going to have a federal estate tax, so you don't have to worry about that. Right now, in 2019, the federal estate tax, the amount that you can pass without actually having to pay a tax, is $11.4 million. So you're going to eliminate that. Most of you are not going to have to worry about probate on the first death, the ALS patient's death. We bet that Christy would die first. We won that bet. It was a pretty safe bet, we hoped. But we did have a living revocable trust, and you need a living revocable trust. The problem is that the majority of trusts in the United States don't work because the attorney never teaches you what to do with it, and you have to use the trust in order to make it work. What you're trying to do with the trust is avoid probate. It's a probate avoidance tool. It is not an asset protection tool. It is not a tax tool. It is a probate avoidance tool. You will have the trust, and the trust needs to be funded. That means it has to own your house. You have to make a deed and transfer it into the trust. It has to own the bank account. You have to go down to the bank and change the signature card. That's what this Protecting Your Financial Future does. In fact, I have a whole other YouTube channel, Lee R. Phillips YouTube channel, and I have now, I think, 200 videos on this estate planning stuff. So you need to study it up. We know that the ALS person is not long lived. The average time to death now is 2.5, 3 years. But some are a lot shorter and some are a lot longer. So it is something you need to think about. I believe I've talked to you about prepaying your funeral. Did I do that, Abby?
Yeah.
Christy and I went on a hot date and picked out coffins and headstones and everything else and paid those. It's about half the price if you pay it ahead of time. So I'd certainly recommend that. And you need the trust. You will have a will that goes along with the trust. It's called a pour-over will. The will is there as a backstop, a safety net, in case something does have to be probated. That means you forgot to put it into the ownership of the trust. If the trust owns it, it's not probated. If the trust doesn't own it, it's going to be probated. Now, those are only assets that you actually have to sign your name for. When you're dead and you are the owner, I can't sign your name. The only way we can get your name off the deed to the house or the signature card at the bank is to get a court order, and that's the probate. The trick to the living revocable trust is you die, you didn't own the bank account. You didn't own the safe deposit box. The trust owned the safe deposit box. The trust owned the house, or the rental unit, or the LLC, or the S corporation, or whatever it is. The trust owned it, you didn't own it. So the owner didn't die. We don't probate IBM's assets when the president of IBM dies. We get a new president, and that guy has full power and authority over all of the assets. You're going to write in your trust who's going to be the trustee after you die. After one spouse dies, usually the other spouse is the trustee. When the other spouse dies, then you name who is going to be the trustee. And I would recommend child, probably, that's my common default. The child needs to be pretty reasonable business-wise. They need to be reasonably close geographically, and they have to be fair and kind. You may not have one of those. You could go to a bank, they love that, they'll charge you 0.5% a year or percent a year of the total assets of the trust. So you won't do that. I got off track. You have the will. It's called a pour-over will. It takes things through probate, if you didn't put them in the trust, and then they pour over into the living revocable trust. They are then distributed or held according to the terms of the trust. You've named the new trustee. That guy has full power and authority over all of those assets. They can sell them. They can do whatever you direct them to do in the trust. You need a durable power of attorney. And it's probably not a bad idea to have that activated now. You will probably have your spouse be the first choice if there's a spouse. If there's not, then one of your children or a trusted individual. That individual will have control over everything that the trust doesn't own. But the trust doesn't own your cell phone. You could sell it on eBay and not have to sign for it. How are you going to turn off the individual's cell phone? I just can't walk down and say, hey, turn Joe's cell phone off. So the power of attorney gives you authority to do all of that sort of stuff. It can be relatively short, 1 or 2 pages. Mine is about 30 pages because I specifically outline what this agent, as they call them, can do on behalf of the principal, the guy who needs the help. So the ALS person is going to be the principal, and somebody, husband, wife, kid, somebody is going to be the agent that takes care of everything that's not in the trust. The trustee takes care of what's in the trust. Yes, the trustee and the agent are often the same person. So you need the durable power of attorney. You're going to need a number of medical documents. A HIPAA agreement so that the family can talk to the doctors about your health care. You need a medical power of attorney so that somebody can make decisions as to your medical care when you can't express them, when you aren't there to do that. You also need probably a DNR, a do not resuscitate, which allows the family, the doctors, to pull the plug and not resuscitate the individual in the end. There's not a lot of use trying to resuscitate an ALS patient. Christy always made me promise that I would let her go on the first opportunity. That could have been a cold. She could have choked. She could have, I might have had to have pulled the ventilator tube. We didn't put a trach tube down her. She didn't want to live that long. You can live a long time on a trach tube. Your body's totally gone. You're pumping air into your lungs. You can get fed through the feeding tube. But Christy promised me not to let her ever have a trach tube. Christy just closed her eyes one day, prayed that she could die, and she went to sleep. I was stunned. I was shocked. But it was a great blessing because I didn't have to pull the tube. I didn't have to decide whether to medicate her when she got a cold and pneumonia and all the rest of that stuff. So that's a personal aspect of estate planning. The power of attorney, the medical power of attorney, the do not resuscitate, all allow the individual to interact with the medical profession. The EMTs, if they're called, they're obligated to help that person to the maximum extent unless you can produce a do not resuscitate order. So these are important documents: the trust, the will, the durable power of attorney, and you probably want the durable power of attorney activated now. You don't wait until a person becomes incompetent, because they're not going to become incompetent with ALS. They're going to become disabled. But you have to go down and act on their behalf at the bank because they can't physically get there and can't express what they want when they do get there. So trust, will, durable power of attorney, and then all of this medical stuff. And the ALS clinics will help you with the medical stuff particularly. They won't help you with the wills and the trusts. Get the Protecting Your Financial Future. It's going to explain it in detail. And by the way, it's a good read. It's a Time Warner Book of the Month Club book, which means Time Warner thinks that little old ladies ought to read it in their book club. And before Oprah, it was the book club. So it's a pretty good book. It's not too bad. It's in like its 8th or 9th edition, but I keep it updated with the tax laws and all of that stuff. So consider estate planning. Don't bury it. Put your head in the sand. It's something you've got to deal with. The earlier you deal with it, the better off you're going to be. Lee Phillips talking on estate planning.